Good afternoon, everyone. John here. Hope you're having a great week. It's hard to believe we're already into week 5, so we're officially halfway done with this course. Um, Anyways, I hope everything's going well. I hope that you're getting some value out of this course, particularly with respect to analysis and thinking about some of these healthcare issues critically. And I think this discussion question from this last week was really great in terms of that exercise of analysis and thinking through critically on evaluating the fact pattern. In this case, it was a privacy issue, 2 scenarios that you were asked to discuss related to whether or not there was a breach. And so I responded to a bunch of the discussion, the initial posts, with respect to the definition of breach. And so, as I said a few weeks ago, we're going to be emphasizing this throughout the entire course, but the way I want you to think about the discussion question and analyze it is much like I want you to think about the legal components of this Giraldi case and how to analyze one of the main legal issues, of course, which is negligence. It's one of the main concepts and legal issues that we're discussing in this class. So when you think about the discussion question, if you go through that, the IRAC method of legal analysis, your first question is, okay, what is the issue? Well, the issue is whether or not there was a breach. And so the next one is a rule. Well, what's the rule? A breach occurs when boom, boom, boom. And I posted the definition for you. And, that definition of breach is a complex definition that that needs to be utilized and analyzed and incorporated in any sort of analysis. So, that definition contained a handful of factors to consider. It contained some exceptions, and so all of which were relevant with respect to this analysis and the facts that were given to you in the discussion question. So the rule, a breach occurs when blah 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 blah. And then there's your application. That's the A, application. Apply the facts to that rule. Well, here X, Y, and Z occurred. Based on these factors, you're applying the rule to those, or applying the facts to that rule, and that's where your analysis comes in. And then the conclusion. Therefore, there was a breach or there wasn't a breach. And if that analysis is reasonable, your conclusion will be reasonable. And so it's really important. I think it's just that discussion question is a great teaching tool to demonstrate the importance of utilizing rules in your analysis. In your analysis. So with respect to the Giraldi case, and you're thinking about the legal components, well, one of the main legal components is negligence. That's one of the causes of action. So there are 4 elements to a negligence case: medical malpractice, duty breach, causation, and damages or harm. And so, the first thing you have to analyze every element, because the absence of even one element means there is no negligence. You have to demonstrate and prove all 4 elements to have a viable negligence claim. So first element is a duty. A duty occurs when that physician-patient relationship is formed, and then that's the rule. What fact in the case, specific fact, would support whether or not that occurred. Then apply that rule, that fact to that rule. That is your conclusion. Therefore, there was a duty. A duty had been formed because there was a physician-patient relationship. Element 2, a breach of that duty. Well, a breach of that duty refers to this whole concept of standard of care. And what's the rule related to standard of care? A reasonable physician You can fill in the rest. Well, Dr. Rickinson did not meet that standard of care because of X, Y, and Z. I mean, all these facts. There are a myriad of facts in the case that you could use and should use to support your analysis. Apply those to the rule, come out with your conclusion. Element 3, causation, and so on. And then, harm. There was harm. So therefore, you have a viable negligence claim. That going through that process is very important in your analysis and thinking about these issues, these legal components critically. Now, this week, your assignment is to take that same case and think about the ethical components. You don't necessarily have elements of a rule when it comes to ethics, but you do have principles and concepts that we've already, and theories that we have already touched base. If you harken back to, I think maybe it was week one, or I think it was week one, where we went over those different theories like autonomy and then the principles like beneficence and so on. So you have those theories, you have those principles that should be used and applied in your analysis of the ethical issues in that case. So as always, if you have any questions, let me know. I'm happy to run through anything, and I just want to help you get value out of this exercise and the things that we're talking about. So I did post a response to a question that had been raised in the general discussion board regarding the shared. There's one of the questions or one of the sections in the rubric for this week's assignment relates to the question about the shared decision model, the physician-patient shared decision model. And I'm having some IT issues with accessing my textbook. I think there is some discussion about that in the textbook. I don't recall exactly where or the extent of that discussion. Please feel free to go outside of the textbook and do your own independent research. I did post a few links that hopefully are helpful. Do not feel like you have to be married to those links. Please feel free to go outside of that in your discussion on that section of the rubric. Please, of course, let me know if you have any questions. Okay, so this week I wanted to talk a little bit about the economics of healthcare. This is the same discussion I had a couple classes ago, where I think halfway through the discussion I paused and stopped myself and actually started hearing the words coming out of my mouth and realized how probably incredibly boring the things were that I was discussing. So hopefully that's not the case. I don't know a way to liven it up, but I do think it's interesting and fascinating, particularly as we approach this election cycle, where it seems like the number one, at least in the Democratic presidential debates, of course, a lot of discussion surrounds healthcare and these things, some of the plans related to Medicare for all, or expanding or enhancing the Affordable Care Act. There are all kinds of different plans, but it's definitely at the top of the list, especially when you have, I think the news article came out the other day in terms of the cost of employer-sponsored group health plans, which is at its highest. It seems like it's breaking a record every year in terms of how expensive these plans are. So that, due to the cost, will cause that issue to rise to the top. So, in terms of the economics of healthcare, there are a variety of different plans or ways that healthcare is paid for. And, there's private insurance. Really you could break it down into two different components: of private insurance and government programs. Private insurance are things like your employer group health plans, your PPOs, HMOs, EPOs. If you work for an organization, you work for an employer, they sponsor that plan. Either they're self-funded, so they pay for their own the claims that that are submitted by their employees that are enrolled in the plan. They could be self-funded ERISA plans, or they're third-party insured, meaning so let's say Corporation X is big enough where they can say, okay, we're gonna self-fund, so we have enough money here where we're gonna pay for all the healthcare claims of our employees. They'll normally hire what's called a third-party administrator to administer claims, to administer benefit, do all the administrative work, but in terms of the actual money, the employer is paying for it. And then there's company X could say, okay, we're not going to self-fund. We're going to go contract with Cigna, for example, to basically fully, it's called a fully insured group health plan, to fully insure the healthcare claims of our employees, and then we'll just pay them a monthly premium. So either way is fine. There's also individual exchange plans. So if you don't have a, I'm sorry, my office light just went out. Give me 1 second. Sorry about that. I guess I need to move around a little bit more to make sure that motion sensor detects me and keeps the light on. So the individual exchange plan. So this is a product of the Affordable Care Act, where you can, if you don't have, an employer that will sponsor and subsidize your health insurance, you can go on to, I don't recall the website, but you can go onto the government website and purchase an exchange plan. And so there's that route. So that's kind of the bulk of the private insurance component. Now the government programs, there are a lot of different programs, plans that fall within this component. The biggest being Medicare, which has been in existence since 1965, largely for individuals who are 65 and older, but also applies to individuals with certain disabilities, with end-stage renal disease, ALS, and there are some others. And there's some other requirements related to citizenship and work credit requirements and things like that. So that's the biggest one. Of course, Medicaid is administered at the state level, although it's also partially federally funded. And that's for more of the low-income folks that meet that state's eligibility criteria. And then there are things like Medicare Advantage, which is sort of this hybrid government administered by what's called a Medicare Advantage organization, which could be your Cigna or Blue Cross or whoever, that they meet certain requirements, and they become a Medicare Advantage plan. There's things like TRICARE, employee benefit health plans, et cetera, et cetera. And the key difference, they're each subject to certain regulations, statutes, requirements. The government programs are subject to other regulatory requirements that the private insurance may not be. Private insurance is largely, there's some exceptions like ERISA plans, for example, but outside of that, largely governed by state law. Government programs, of course, even Medicaid, although every state has their own Medicaid rules and regulations, also governed by federal law. So I think a good example is the False Claims Act, which prohibits a provider or anyone from submitting a claim to the government that they know to be false. And we could spend a couple hours on what that means, but that applies to a claim for funds from a federal program. So that could be Medicare, Medicaid, it could be any of these things. That doesn't necessarily, at least the Federal False Claims Act does not necessarily apply to private insurance, although the state where that private insurance is licensed may have a similar state law, and some states do. So there are other, like the Stark Law, which we'll talk about here in a second, anti-kickback statute. All those apply to certain government programs, do not apply to private insurance, although many states have similar laws that apply to private insurance, but not all states do. So the business of healthcare, I do a lot of this. Where in fact a few weeks ago I helped a physician form a medical group. We do a lot of this where a physician and a company will come together to purchase an existing practice, or create a new practice. I have a client that is he's an orthodontist that wants to buy a rheumatology practice, and so there are certain rules and regulations that they have to comply with in order to do that. One being the corporate practice of medicine. Not all states adhere to this. Not all states have this. It is a state law issue, but it basically says that a corporation cannot practice medicine. And so you cannot have a formed entity like an LLC or a C corporation or anything like that cannot practice medicine, cannot employ physicians or other similar types of providers for the practice of medicine. Many states don't allow that. However, basically it has to be the practice has to be owned by a professional entity, which has to be owned by a physician, and that, like I said, the laws on that vary pretty widely from state to state. So I'm just kind of giving you a general overview. But a lot of times, we're able to work around that, where the physician will own the practice, but the practice contracts with a management company that's owned by this separate LLC or corporation, and they enter into a management services arrangement, and then they're able to get revenue through the practice, from the practice, through the management company. So there are a lot of ways to do it, but just so you corporate practice of medicine doctrine, that's essentially what it says. Other regulations that affect sort of the business and economics of healthcare. A lot of states have no fee splitting rules, which says like a physician can't accept a fee from a patient and then split that with another non-physician who maybe provided the referral. So essentially what that says is a physician can't come up to me. I'm not a physician. Can't come up to me and say, hey, if for every patient you send me, I'll give you $50 and we'll split the fee. That's inconsistent with many laws, including the no fee splitting law that many states have. Other federal laws that are sort of like that are the anti-kickback statute. It's a federal criminal statute, but also there's a civil monetary penalty component to that says you can't solicit, you can't induce, you can't refer. Basically, you can't pay for referrals of patients that are paid for through a federal healthcare program. So this, like for Medicare patients, Medicaid, VA, Medicare Advantage, et cetera, essentially you can't give a doctor can't just go give you a bag of cash in exchange for patients that are enrolled in any of these programs and that they bill for. So that's against the law. The Stark law is limited to generally just Medicare, but it essentially prohibits physicians from self-referring. So what that means is a physician, it only applies to physicians, can't refer to an entity in which the physician, with which the physician has a financial relationship. So what that means is, for example, let's say a physician has a 50% ownership in a diagnostic imaging company. The physician cannot refer patients, Medicare patients, for imaging, X-rays, et cetera, to that diagnostic imaging company in which that the physician has an ownership interest in, unless an exception applies, and there are a handful of exceptions. It only applies to certain types of healthcare services. It doesn't apply to everything. So those healthcare services are called designated health services, and there's a list of those types of services. So anyways, I mean, they're all laws designed to prevent overutilization, and to kind of remove the incentive of lining your own pockets with federal dollars, by referring patients to your own company, essentially. So anyways, again, that was probably super boring. I get it, but I think it's important. I think it's important to know how the business of healthcare works. And although this was just a super high level 15-minute overview of that, it's actually quite complex, as I'm sure you know. And the economics of healthcare is always quite interesting. So on that, please remember what I said about the analysis stuff. If you have any questions, please reach out and let me know. You know how to contact me, and I try to be pretty responsive. I am around all this week. This weekend, I am going back to Kansas for my law school reunion, which is a great reminder of how old I have become. And but I will be available and around. So feel free to reach out if you have any questions. Hope you have a great week. Take care. Bye.